Okay, hello everybody. Welcome to TechFreedom's organized webinar to discuss potential and nascent competition and revisions or possible revisions to the merger guidelines. We've got a good panel here. I think we're waiting on Sean to join, but let me quickly run down who we have here. We've got, in addition to myself, who will just be doing the moderating, we've got Daniel Francis, who right now is an assistant professor of law at NYU, and of course, former deputy director and other positions at the FTC. Kristen Lamarzi, who is presently a partner at Gibson Dunn, and among other things, former section chief at the Antitrust Division. Henry Sue, partner at Bradley, and a former attorney at the FTC, including 2 stints as attorney advisor, once to Chairwoman Ramirez and once to Commissioner Roche. Sean Sullivan, who we're waiting for, is a professor at the University of Iowa College of Law, and also a former attorney at the FTC. Tom Wollman is an associate professor of economics at the Booth School of Business at the University of Chicago, and a research fellow at the NBER, and has written extensively on roll-up, what I'll call roll-up, but maybe they're rather small acquisitions. And finally, John Yoon, who's associate professor of law at George Mason University's Antonin Scalia of Law, the Deputy Executive Director of the Global Antitrust Institute, and among other things, former Acting Deputy Assistant Director of the Bureau of Economics at the FTC, and former Economic Advisor to Commissioner Josh Wright. So I'd like to jump right into this. Sean will join, hopefully when he can. We are scheduled to go 90 minutes till roughly 3:30. But we have a lot to cover, and a few folks are able to stay beyond 3:30. So while we'll have some shuffling in and out, we may run till 4, if not so much if there's interest, but if the remaining panelists are interested. So we may go a little bit long, and you're welcome to stay or not. This whole thing is being recorded for YouTube, so you can watch it in the in the late evening hours when less busy. And Sean has joined. Sean, you missed your introduction, but I did a reasonable job of introducing him. Okay, so first question I'm going to put to John, right? To just table set us. What are we talking about when we say potential competition and nascent competition? Are these the same thing? Are they different? Is there some blending? Do the guidelines touch on this issue directly or indirectly with references to fringe competition or competition from a maverick? So let me turn it over to John to kick us off.
Thank you, Bilal, and thank you, TechFreedom, and for everyone for tuning in today. So as the saying goes, obviously words matter, and it really matters as it applies to this area of the law and also the economics. So, I'll try to be brief here, but let me just go through these terms, the first of which is potential competition. This phrase came out of the Supreme Court in the 1960s and 70s. I'm thinking of 2 major cases. They might have been others, but it's El Paso Natural Gas and Falstaff Brewing. And I won't bore you the details of the specifics of this case, but what's really important is what the court recognized is that while you don't have to be an immediate competitor in a market, you can constrain either actively or perhaps sometime in the future the competitive conditions today. And so you provide a benefit to consumers, again, either immediately or sometime in the near future. They added different terms to that, but I don't think that's really that important for our discussion. But what's also important are the nature of the products involved in these markets. We're talking natural gas, bleach, extension into one geographic market from another. And so these are very basic level of entry questions that did not involve a lot of complex technologies. In contrast, this doctrine of nascent competition I think really arose out of Microsoft. I don't know if there were another case before this. And obviously Microsoft in the late 1990s was a section 1 or 2 case, if not both, of the Sherman Act. So it's not a merger case, but still the elements of Microsoft still inform how we think about nascent competition today. And what is that? Well, the idea in that case was that Netscape had this browser, and it's not that it was a challenging Internet Explorer, and that competition is what the DOJ was really worried about. They were to one degree, but they were really worried about what it could do for Microsoft's crown jewel, which was the operating system, the Windows operating system. And so it represented a technology that had not yet evolved, an existing product, a very useful product as a browser, but could evolve technically, which Microsoft and Bill Gates recognized could then chip away at Microsoft's monopoly in the future. I think this is really incredibly important because potential competition cases require a very strong standard in which the court demands good proof of entry or likelihood of entry, whereas nascent is more speculative. And so why does this matter? Why do these terms matter? Can't we just kind of make them, we'll have it all as one big category? It matters because I think the FTC had an uphill battle in FTC versus Steris because they chose the wrong doctrine. And so again, let me just be very brief on this. That was a case involving technology to sterilize medical equipment. Obviously, if you get an artificial hip, you want to make sure that that thing's really clean before it goes in your body. There's different technologies to do that cleaning. And so this merger involved companies that had different technologies. The FTC brought this case as a potential competition case. And so it ran against all the case law and the precedent the court set for these basic products of natural gas, bleach, beer to extend from one market to another. And so they had a very high bar and the FTC didn't meet it, that it would be some likelihood of entry. I'm not saying the FTC would have won if they brought it as a nascent competition case, but I think it would have at least been in its right category. It would have been a lot more easier for the FTC. And so that's why I think at the end of the day, these terms matter. And I think the case law supports that, and the economics are a little bit different as well.
Super, John. Thank you. Let me ask, although we're going to turn to Henry, let me ask if anyone has any immediate thoughts on that. And if not, maybe Henry, can I ask you to talk a little bit more about the law with respect to potential competition? And is there anything more than John identified with respect to nascent competition? Both John mentioned Steris. Daniel mentioned to me sort of the I think either his words or mine, right? The inordinate weight that Steris is sort of putting on is carrying with respect to potential competition doctrine. The likelihood of entry, reasonableness of reasonable probability of entry. So anyway, let me turn it to you. Just a little background on the hard issues of law before we jump into guidelines, specific stuff.
Sure, thanks, Bilal. And again, also thanks to TechFreedom for inviting me. Was able to change my flight, so I'm glad to be able to join you all for this. Hopefully, what will be a very stimulating discussion. So as John mentioned, back in the 60s, 70s, you have a couple of key cases: Falstaff, El Paso. There's also Marine Bancorp. These cases kind of that current cornerstone of what we're calling our potential competition doctrine. And there are actually two species of potential competition, that have developed in merger law, right? So there's something we call perceived potential competition and something that we call actual potential competition. And actual potential competition is the theory where, the firm that's being acquired, or one of the firms that's being acquired, may be itself an independent entrant, but for the merger. And so the worry is that the merger eliminates this firm that could otherwise, at some point in the future, enter on its own, right? Or maybe there's a variant of that where the acquirer of that firm might have entered on its own, through a toehold or something like that, but instead it's acquiring this small firm. Then there's what we call perceived potential competition doctrine, which says that, okay, there are firms out there that are not yet in our current market that we're defining, but nonetheless, because of what people perceive about what they might do in the future, they're exerting some sort of constraining influence on competition today. And when you read the Supreme Court cases, Falstaff, Marine Bancorp, El Paso, what the Supreme Court, clearly endorses is that perceived potential competition theory, this idea that firms that are not quite yet in our market can nonetheless exert some sort of constraining influence and competition in the market. The Supreme Court has never, blessed the other theory, the actual potential competition theory. We do have some, Court of Appeals decisions that have talked about that. And that, candidly, that seems to be the one that's of most interest today, right? It's the idea that there is this firm out there that one day could become something really important. I think, that's the Steris case. And that's the one that sort of, created more difficulties for merger enforcement. Now, let me talk briefly about kind of why I think there's a judicial preference for, Steris is S-T-E-R-I-S, Steris. It's like sterilizing, using X-rays to sterilize things. So let me talk a little bit about why I think there's a judicial preference for the perceived potential competition theory over the actual potential competition theory. And that's because we like to think about the present. It's hard enough to kind of, it's hard to predict the future. So it's, kind of atmospherically, perceived potential competition is about looking at the present. What is going on in the present? You've got some firms, after you define the relevant market, you've got some firms that are in the market, but there are these other firms out there that aren't in the market, but maybe they still have some influence. So kind of with thinking about it, we're still thinking about the present. We're still thinking about what, the incumbents in that market think of these other firms that are kind of on the outside. So those are some thoughts I have for you, Bilal, about that.
Okay, excellent. Well, we're gonna explore those a little bit as we sort of now turn to, what's in the guidelines today and what maybe should be added or perhaps subtracted from the guidelines. Now, I was in jest originally thinking of calling this panel program, Shapiro, Farrell, and Shalansky got it right in the guidelines back in 2010. But of course, both a number of people who I respect, including John Quokka and Herb Hovenkamp, have said to me, directly or indirectly, that maybe the guidelines could take potential competition more seriously. And so I proposed a more neutral title. So, Kristen, you've written, in particular, what you've written with Greg Worden on this question of, the superfluity of the potential competition doctrine. And so I wonder now, about 10 years beyond that article, what do you think? Do the guidelines, both the horizontal merger guidelines and the vertical guidelines, address harm that may result from the acquisition of a potential or nascent competitor? And how do they do that?
Sure. And thanks, Bilal, and thank you for having me. So do the 2010 guidelines address potential competition? I think yes and no, and I think the history is relevant here, right? There's not a separate section in the 2010 guidelines titled potential competition or nascent competitor acquisitions. And I think happily the guidelines eschewed the perceived potential, actual potential morass that we've just been talking about. But there is a definition of market participants, right, in the guidelines, and it includes firms that are not currently earning revenue in the market, but have committed to entering the market in the near future, or are perhaps already vying for sales, or about to vie for sales. And I think that is an acknowledgement in the guidelines, and we'll talk a little bit more about how this is a bit of a double-edged sword, but it's an acknowledgement that someone can be a market participant and thus their acquisition can impact concentration or competitive effects in a market, even if they're not presently earning revenue. And we have other means to measure that, right? Looking at their capacity, looking at the demonstrated efforts to enter the market. And there are industries in which that's easier and industries in which that's harder, but the inquiry is the same. And that shift in the guidelines, you know, it didn't happen in 2010. That goes back to the 1992 guidelines. And I think it was a substantial step forward from this historical rubric of perceived potential competition, actual potential competition. Because recall, those doctrines set sort of quasi-separate elements for Clayton Act violations that were evidently so rarely seen in the wild that almost no cases were successful under those theories. But in 1992, and then again in 2010, the agency say, this isn't a separate mode of analysis. This isn't a unique, different claim under the Clayton Act. The inquiry under the Clayton Act is the same. It's a forward-looking statute. It applies an incipiency standard, and that enables us within the rubric, the existing rubric of Section 7 law, to analyze these sorts of transactions and to get at this without a lot of this sort of extra tortured rhetoric. And so I think that's how you see it showing up in the guidelines, and I think there's a lot of benefit to that. It will be, I know there is obviously a lot of different camps interested in addressing these sorts of acquisitions more directly in the guidelines. And in my view, the sort of success or lack thereof of the perceived potential competition and actual potential competition theories in the case law is a bit of a cautionary tale on that front.
All right, super. First I'll ask if anyone wants to comment on what we've heard so far. Noting that we are now sort of going to move into this discussion of, you know, how to improve, assuming they need improvement, the guidelines. So first I'll ask if anyone wants to comment on what has been said so far.
Yeah, okay, if I could, Bilal, I'll just add something.
Absolutely.
I mean, I totally agree with Kristen and Greg that, you know, it's superfluous to talk about a potential competition theory. I mean, as Kristen said, Section 7 and, you know, embraces a likelihood standard. So we're always talking about likelihood that a merger changes either the present or changes the future, right? And so, you know, analytically, we're well equipped to evaluate the evidence, the economics on whether either of those possibilities or both of them are true. And, you know, and then we have an evidentiary standard that's supplied by Brown-Shue, which says that, you know, we look for probabilities, not mere possibilities. So it's all there. I don't know that, you know, the new guidelines need to specifically address either perceived potential competition or actual potential competition. I mean, you know, it's there. And later on, I'll talk about what I think the guidelines can instead do that we're not seeing right now. So.
Okay, super. I'll make one comment and then kick it over to Daniel. You know, I think what's also been lost, maybe it's been lost, is that, you know, the guidelines, in fact, make better the doctrine. You know, they incorporate perceived potential entrants and actual potential entrants in a way that has, I think, proved, you know, more successful. And I think people recognize that with respect to the market participant, you know, analysis, which includes both, I think, perceived and actual potential entrants, but, you know, in a way that the case law did not. I mean, I think the case law did put some high hurdles there, and the guidelines have I think lowered them. So I think that is something worth considering, and you know, bringing back those terms may slow that evolution, may reverse that evolution. So let me turn it over to Daniel, and I think the first question we have is, you know, about the legal standard and evidentiary standards there is some reference to the law, at least the statutes in the guidelines, and there's a discussion of evidence. So what, Daniel, for you and others, what are the proper legal and evidentiary standards here, right? Section 7 has a couple prohibitions. We've got Section 2, we've got Section 5, and we also have Section 1. So let me kick it to you.
Sure. Happy to go first on that. So I want to start by picking up on the exchange between Kristen and Henry there, because I sort of am against nascent competition or potential competition exceptionalism in a sense, right? So just as Kristen mentioned, merger law is always concerned with the future, right? The story is always of a lost counterfactual future that would have been better for competition than the world that we're in as a result of the transaction. And sometimes we're using the status quo as a proxy for that lost future. But other times we got a story about how entry, what I would think of as a potential competition case, or expansion or growth, what I would think of as a nascent competition case, would take place in that counterfactual. And so when we're telling that story about, hey, had it not been for the merger, we'll talk a little bit about that probability question in a sec, but had it not been for the merger, one of these parties would have entered or expanded in a way that would have led to more competition. And I think there are just three questions that I sometimes think of as the coulda, woulda, and shoulda, right? Coulda is whether or not entry would have been available. I look back at Marine Bancor and those other cases, and I actually find reasonably permissive standards in there. Feasible means is the language that the court uses in Marine Bancor. Pops up again in the 8th Circuit in Yamaha Motor, right? Another case that gets a lot of opinion. Then woulda is a story about incentive or the probability of entry. And shoulda is a story about how competition would be better, more intensive in that but-for world. And those two, I think, come together in what the Marine Bancor Court and the 8th Circuit and Yamaha Motor call the substantial likelihood of deconcentration. And I strongly feel that Steris, which at the end of the day is a it's sort of one-off decision from the Northern District of Ohio, ends up exerting much more gravitational force than perhaps we might wish when it comes to thinking about what the rules really are for competition theories built on a lost future where competition would have been greater than in the status quo. So in that world, what do I think we do with the guidelines? I mean, I don't think there's a way to write merger guidelines that doesn't reflect an underlying understanding of what the legal standards are. We're in this funny spot with Section 7, where one of the most difficult riddles in all of merger control law is, well, gosh, what's the affirmative standard, right? We have this peculiar language in Section 7, transactions illegal, we heard likelihood a minute ago, but that's not what the statute says. Statute says transactions illegal if the effect may be substantially to lessen competition or tend to create a monopoly. So I'm just going to set aside tend to create a monopoly for a second. And I'll just say a couple things about that underlying core standard that gets so much attention and is the center of most merger cases, virtually all merger cases. It pretty clearly has two dimensions, right? One is about the likelihood of harm that may be. The other is about the magnitude of harm to competition, that substantial lessening of competition. And I'd say a couple things about it. I was actually looking back at the congressional debates this morning as I was sort of thinking about some of this stuff. Number one, it is super clear that the choice of maybe, which is not language you see in Section 1, it's not language you see in Section 2, was not accidental. That was specifically inserted. They struck out is, and they put maybe, and they did it animated by this real concern that Section 7 might not reach broadly enough. And, it's pretty clear. I think it was Senator Reid who put it in, who spends all his time in these debates talking about wanting to make sure Section 7 is reaching far enough. Others, Senator Chilton from West Virginia, seems to identify it with a possibility standard and says it's easily proved, right? So it's not an accident. It can't possibly mean on the balance of probabilities, the effect was in fact to lessen competition, right? That would read that change totally out. But likewise, it can't mean a mere possibility. And the court, even in brown shoe, right, what we might think of as the high watermark of merger control law, says no. A distant possibility of competitive impact ain't going to be enough. So where do I come out? I think the most natural reading for me of maybe substantially to lessen, maybe, to substantially lessen competition is a reasonable probability. In my mind, it's something like 40%. I identify it with the Section 2 standard about reasonably capable of making a significant contribution to monopoly. The substantial as a measure of competitive impact, to my mind, and it seems in the contemporaneous debates, that is not 1,000 miles away from unreasonable impact on competition. Antitrust is never concerned with de minimis competitive impacts. And I will just be honest, I have no idea what to make of tend to create a monopoly. It clearly comes in late in the drafting process. For years, I've kind of had the background idea, gosh, this could be a really interesting basis for, serial acquisitions or a sort of broader approach to thinking about merger causation. Doesn't seem to have been intended that way. And in fact, the term monopoly seems to have been understood in some of these debates pretty narrowly in ways that sort of surprises me now going back to it. But at the end of the day, number one, I think the legal standard here, setting aside the fact that Steris and other cases have caused all kinds of heartache and problems, is we're looking for a reasonable probability, something like 40%, of a significant impact on competition. That's enough. And I think it would be just fine for the guidelines to say that's what the agencies are going to look for. These are the kinds of evidence that might be helpful to us or will be helpful to us in the standard case. And here's the kind of thing we're going to look for when we do.
Well, let me pick up on that and ask, I have a few questions, but let me ask the group what they think of the 40% standard for reasonable probability. And I say that because, and Daniel knows at least some of this, when I was at the commission sort of thinking about this, I sort of polled people who I thought, were very thoughtful and threw out percentages, assuming you could determine percentage, and said, well, what do you think of, 50% plus one versus, just under 50%, and then moved in increments of about 10%. And I think the one common view I got was that below 20% was probably too low, right? And, people were, I don't want to say all over the map, but actually, I thought it was actually quite reasonable, settling sort of in the range of about 30%. So anyway, what do people think of this? Assuming you can measure this, which is tricky, more than tricky. What do people think of that 40%? We have two economists here, at least, maybe three.
I'll just say something really quick. And I think you've kind of assumed the problem away, Bilal, when you say assume we can come up with enough measure. How do you operationalize 40%? And I get what Daniel is saying, and I like his sentiment about trying to get a sense of what this means. For me, and I know I'm an economist, I know the legal training is quite different, but when it comes to the antitrust law, and I think this has been said, but sort of parsing the language, I think we can get into a lot of trouble. Part of it is line of commerce. Is that mapping to our relevant product markets today, which are so narrow? If you look back at the legislative history, they were talking about adjacent related markets that aren't necessarily in the market of competitive harm when they were passing the 1950 amendments to clarify the language. So should we have more expansive views of efficiencies? And so I think ultimately, the reason why the consumer welfare standard, as with the notion that we need to weigh pro and anti-competitive effects, and on that see which one, and of course we all acknowledge these are uncertain exercises, is so powerful and so attractive, I think, for such a long time for courts, is it's something that you can operationalize. I don't want to say it's easy. We use presumptions, we use certain cases to make it easier, but at least it's an objective that to me is achievable. Whereas I think broader notions of probabilities are just inherently more difficult, even if I agree that that sentiment perhaps is pretty close to the language of the doctrine of the statutes.
Right, but you can have a welfare standard, the choice of a welfare standard or any other normative orientation for antitrust is totally agnostic about the probability threshold for liability under Section 7, isn't it? You can hold that view and say, hey, for reasons connected to or grounded in the promotion of welfare, we think it should be set at 70% confidence or 28% confidence, right? I take it to be somewhat orthogonal.
Bilal, I have a thought that I can share, and I will play devil's advocate in disagreeing with my friend Daniel, which I don't do lightly and which I think we'll end up agreeing on everything if we were to keep talking. So I have 3 points on which I would push back. One is the starting premise of kind of your pushback on nascent and potential competition exceptionalism. I think I buy you on nascent, but not potential competition, which is to say a nascent competitor is a competitor. And if we think that its significance in the market is disproportionate to its current share or posture, that's all something that we can deal with. General dynamics has been on the books for a long time. And if it works in the direction of general dynamics, I feel it should work the other direction too. So I completely buy you there. Potential competition does seem to be discretely different to me. For one thing, the economics of entry games are different than the economics of existing oligopoly games, at least the way we think about them. It's not to say that they're fundamentally different in some metaphysical sense, but our way of thinking about them as economists is a bit different, and it would be a little surprising if the law didn't reflect that to me. Moreover, even talking about the probability of entry in the first place only makes sense for a potential competitor not currently entered. So just the language itself does seem to me to separate these. I agree with you on nascent, but potential seems different. The second point that I would kind of push back on, I don't disagree that both the probability of entry and the substantiality of entry matter, but to my mind, it's more natural to merge them, either as an expectation of harm or some type of other nonlinear function. The Supreme Court said in Procter & Gamble that there isn't a single standard, that the standard depends on the context. And it seems to me, there it was talking about the amount of harm, but it seems to me it's both. A low probability of entry might be sufficient if it would foreclose a huge amount of harm, and vice versa. It seems to me you just can't separate them too cleanly. And that gets me to the final point, the 40% thing. I have no idea. It's anytime you put a number on anything, I think you have immediately invited everyone to criticize you on it. But I would at least say on that point, 40% seems to me to be potentially right, but it depends on the amount of harm and the context. Courts have always avoided any effort to quantify anything in antitrust, and I kind of have the suspicion that any effort to put a number on anything is just going to get you slapped immediately.
I guess as an empiricist, I would add that I would feel somewhat better if it didn't sound as if the number was coming out of thin air. Of course, it is supported by Bilal's highly scientific polling surveying process. So there's that. I guess what's going to happen now is Daniel's going to say to me, then you should go estimate this and figure out what the right number is. And I'm going to say, I'm busy, and then, and this takes too long and so forth. And I think that's in a way, maybe the state of the art, but putting that aside, it seems reasonable.
And maybe I should have been a little clearer. I'm not contemplating putting 40% on paper anywhere it might embarrass anyone or indeed be the subject of any questions at all. I'm just, for two reasons, right? One, just as John said, and as others have suggested, we live in such an empirical desert almost all of the time, above all in individual litigations and investigations. So the idea we can go out there with our probabilityometer and say, oh, this is only 39%, guess we're going home, everyone. Like, that's wild. I think qualitative standards work pretty well for everyday purposes across the law. I think we use concepts like reasonable probability every day of the week in other areas of law without pulling our hair out about it. I just, sometimes people say, well, what do you mean by that? Put it on a scale between 1 and 100. So I admit, for, in the interests of bearing what's in my soul, that 40% is what I have secretly in mind, but I guess I've made a mistake in.
Well, it's brave of you to say it out loud, Daniel, since evidently you're going to be shouted down for it. Just to add to one thought on this. So I agree, right? Maybe 40% is right, but what are you measuring against that, even if you determined it was right? And how does a court operationalize that? I think the flexibility of the antitrust law is both its greatest strength and its greatest challenge. And that's not unique to merger review. And then the other, just one comment in response to Sean's point about the difference between nascent and potential. And this is where we also have this tendency in antitrust law to torture terminology, CEG, consumer welfare, CEG, killer acquisition. I'm not sure I'm not sure we have a common understanding of the difference between potential and nascent, nor do I think there are bright lines between them, right? I think in addition to the probability exercise that Daniel's engaged in terms of the probability of substantial lessening of competition, when you're talking about potential competitors or nascent competitors or whatever we're calling these things, there's a probabilistic inquiry there as well, right? I'm a potential entrant into the medical device sterilization market that was at issue in Steris, but the odds of my actual entry are vanishingly small. And there is a continuum between me and someone who actually has the means, motive, capability, knowledge, any of those things to actually enter that market. And part of that is what you are evaluating. That is a probabilistic inquiry that you are layering on top of what is already a probabilistic inquiry about the impact of that on future competition. And then you're layering on top of that whether that impact would be substantial, right? And that's what makes these cases hard. But I'm not sure that trying to put more labels or columns or guardrails around it really helps us more than it gives us things to argue about that aren't about actual impact on competition.
So let me make one comment. I mean, I think what is important here, or maybe easily recognizable, is Steris. I heard former chairwoman Ramirez say one of the problems with Steris was a view that entry had to be more likely than not. And there's also some flavor of that in the 1980s cases that either the commission or the appellate courts looked at, in terms of, very high probability of entry. And I think at least what we're hearing among this group is a recognition that high probability, maybe even, 50-50, is probably too high, both given the statute and maybe even the potential economic effects, as the focus on magnitude of harm. So I think that I think it would be, the guidelines in fact don't, the merger guidelines don't include a language about probability. The competitor collaboration guidelines do talk about reasonably probable, and it might be good for the agency to clarify that this is not, at least in their view, if true, not a more likely than not, standard, and maybe include some magnitude language. So let me, unless anyone wants to say anything else, I'd move us along to market definition, right? Sort of, the guidelines are mostly an analytical framework, not a legal framework. And so what about market definition? I mean, are there theories of market definition? Are there clarifications to market definition that may better accommodate harms associated with the elimination of a potential or nascent competitor? And I'll ask Sean to take a crack at that, since he's got an article, a recent article.
I've written more about market definition than a human should, which also means I have unreasonably specific opinions on the topic, so I apologize in advance. The 2010 guidelines are excellent in many respects. I'm on record saying I think that they missed some beats on market definition. Taking a step back, my basic thesis on market definition is that we are far too obsessed with the word market, and we pay far too little attention to the word relevant. We define relevant markets in order to assess specific theories of harm. The relevant comes in the same sense that we think about relevant evidence. If the market doesn't fit the harm we're thinking about, it's not relevant. It's not helpful to us. And so if you take that approach, that suggests that we don't define a market, then sit and look at our toy market and try to figure out what theories can work within it, which is in many respects kind of the framework that the 2010 guidelines provide. There's escape language around it, but it's kind of a carryover from earlier guidelines. That was the way they proceeded. Instead, the right way to do market definition is to start with what your plausible theories of harm are and to figure out what relevant markets are for those different theories of harm. That might suggest multiple markets. It might be one market. I don't have an opinion on that. But if you kind of look at the world in that way, then what the merger guidelines currently do is, in every case, define a relevant market using a tool that identifies useful relevant markets for thinking about coordinated effects. Sometimes that's helpful. If we have a coordinated effects case, great, we've done the right thing. If we're looking at a unilateral effects theory, it's not particularly helpful in most cases. Occasionally, it will accidentally provide helpful information by virtue of the ability to overload market shares as indications of diversion, but that's more of an accident than an intentional thing. If you look at the world that way, then your question of, well, how should market definition be used in a potential competition case can kind of be answered by saying, well, it depends on what the potential competition case is about. It's not that market definition as the guidelines articulate it couldn't theoretically be helpful. So if your theory is that competitors in a relevant market would be colluding, but for the presence of this threatening disruptive competitor on the edge of the market in a perceived potential competition sense, well, then we can proceed like normal. The theory of harm is that once that potential competitor is eliminated as a restraint, firms in the market will begin to collude. And that's exactly the question that the hypothetical monopolist test in its usual articulation captures. It's asking who would need to collude with each other to raise price. But that's only one case, and there's others that wouldn't work with the current framework. If we're thinking about a potential competitor and we're worried about the elimination of its future effect on the market. So the idea is by becoming acquired by some firm, it won't enter the market in the future. And but for that, it would have entered depressing price, increasing competition, etc. Well, then defining a market by the hypothetical monopolist test looking at a price increase is a very strange and inappropriate exercise. The theory of harm wasn't that anyone was going to raise price. The theory of harm was that if we if we blocked the merger, price might go down in the future. So if you look at the world that way, then suddenly we're basically in the cellophane trap in a Section 2 case. What we're doing with market definition, if anything, is really looking at a group of competitors that have already raised price and sort of asking, well, could price be depressed as a result of this? The usual articulation of the hypothetical monopolist test doesn't help there at all. So a big picture answer to your question, at least for my opinion on it, is here, when thinking about potential competition, we need to be a lot more specific. Potential competition alone is not enough to say how we should be defining markets. We really need to say, what's the theory of harm? Is it an effect that's decreasing current price? Is it an effect that would decrease future price? How would it do so? Would it disrupt coordination? Would it prevent an otherwise unilateral effect that would be a decrease unilaterally in price? What's the theory of harm? And then we can figure out a relevant market for that. But the generalizable point is that this is true everywhere. This isn't specific to potential competition cases. We could do much better with market definition in the merger guidelines if we thought in this more flexible way in every case. So all of that was answering your question on market definition. It generalizes in an intuitive way to market shares and market share analysis. The guidelines have kind of carried forward from earlier versions the use of market shares for presumptions of harm. Really what that was a carryover from work in the 1982 guidelines that was really focused on coordinated effects. And so we're presuming coordinated effects on the basis of share analysis. Again, that doesn't generalize beyond coordinated effects in an obvious way. So share analysis similarly really should be different depending on the different types of harm. I'll pause there because I fear I've bored everyone to the point where they're going to induce or fall asleep. So I'll take pushback, but otherwise I'll step down.
Well, let me first say, I look, anyone who's attending this webinar probably was not bored by that.
I thought you were going to say is already dead, but that's
I'll ask one question and then maybe open it up for comments and maybe ask John to comment first. But I sort of set the stage as saying, should something be, added to the guidelines to make these cases more tractable? In listening to you, my question, I turn it around, which is, is the language in the guidelines now a hindrance to this type, this type of, in a sense, case by case or theory by theory analysis, right? My view is the guidelines are a framework, not a recipe, and they've become over time more of a recipe, but that can have its difficulties. So I throw that out there, and then let me ask John if he's got any comments on what he's heard, and then we can open it up to others.
No, I appreciated Sean's insights on that. I'll defer to others if they have some strong thoughts on that. I don't have a strong view.
Well, I don't know if I would describe mine as strong, but I would say that, having seen my time at the agency and including through the rewriting of the 2010 guidelines, I think in practice, Sean, the agencies are using them much closer to the way that you describe as ideal, right? I mean, and the guidelines in their language acknowledge this, but I think elsewhere people say it's not a stepwise framework, right? And for exactly the reason you say, it makes no sense to define a market in a vacuum, right? I mean, you're only defining a market for a particular purpose of analysis. And so I think in practice, the agencies are looking at theories of harm and then working back to what is the right market to analyze that. And market definition is a useful then check on, am I looking at all of the sort of competitive forces that would be relevant to my theory of harm? So I think it's a useful exercise, but the idea that it comes first, I think in practice is inaccurate. I think the market share and sort of HHI analysis is different. I don't view the guidelines as maybe the guidelines contribute to this, but I think the case law and the presumption, the Philadelphia National Bank presumption, I think forces the agencies to put a great deal of weight on market share pretty early in the process, because if you are thinking about a challenge and thinking about litigating it, it's a very rational exercise to go through and make sure that you've constructed your litigation in such a way that you can take advantage of that, right? And so I think that more so than the sort of recipe nature of the guidelines sort of pushes on that direction.
Below, maybe I'd add to that. I think part of the trouble is, and I think this is in around section 5.3 in the guidelines, talks of projected market shares. And so when you think about what I mean, it's hard to imagine us doing this in a disciplined way for competition that is not incipient, basically. It's unclear. Let's say we were to think about this firm coming into the marketplace. How much share do we ascribe them? Would we make them the smallest competitor currently in the marketplace? Should they share, split the market share, so to speak? And I really don't know. You step back to section 4 that is specific to market definitions. And I think what you need to do maybe in a way is relax some of the language. So for instance, I've thought about this with two co-authors, Matt Grennan and Ashley Swanson, who are at Berkeley and Wisconsin. And we're basically asking here, could you use patents, for example, in a disciplined way? Let's say you had measures like you have of any other market. Could you draw a market boundary with them? And I think what we're finding, at least at this point, is yes, you could. Like that's it's possible, but you'd have to get a lot of buy-in. You'd have to be really disciplined about what the agreed upon measure is. And just to give you one idea, if you try to measure, draw a market boundary, which is the substantial problem here, using like patent classes, it's awful. I mean, it's basically nothing but noise. Now you employ something modestly more sophisticated, like in a AI type framework, some neural net or whatever, to try to incorporate the language, the corpus of the claims and the abstract and so forth. You do really well, at least gauged so far in what we've seen, how it lines up with divestitures and so forth. And so I think in many ways that should make us hopeful that we can do something about this in the future. But I think to Sean's point, it's a lot more complicated than just drawing a strict boundary and moving on.
Can I ask a question? In terms of thinking about whether there's something, in a sense, missing from the guidelines, I think there would be value in adding sort of a discussion of different categories of possible relevant markets, right? I mean, mostly we think about, present goods or present services market. Some consents, even outside the pharma space, talk about future goods. There are a handful of technology market cases, mostly but not exclusively on sort of the non-merger side, and even innovation or R&D markets. I mean, that in particular is subject to criticism, but I've wondered if the agencies over time would have both an easier and better ability to convince a court of harm in the future if the guidelines in fact articulated markets that are sort of future oriented, right? Doesn't need to be much. You can pick up the language in most cases from the IP guidelines, but I wonder, and I wonder about that in part because John Quokka in an article, probably 20 years ago, thinking about potential competition, said, maybe innovation markets, but not really, would be helpful. And John has sort of carried the flame of potential competition longer than anyone, I think. So I wonder what people think. I don't think it's harmful. I think innovation markets probably should be used, in narrow circumstances. But I wonder, particularly as we talk about tech companies, why we're not alleging technology markets more often. So I'll throw that out there. If anyone wants to comment, please do. Otherwise, I'll think of it as just a pet issue for me and nobody else.
But I can give you at least a little pushback on it. I think the germ of the idea is that we should be defining markets that are appropriate to the thing we're worried about. If you're worried about effects on future competition, we should be focusing on a future market, not on the present market that's missing the point. Completely agree on that. I think the nightmare scenario is a world in which everyone's sitting around a table debating whether we're talking about a technology market or a future market, right? When the categorization becomes the game, then lawyers are delighted and the rest of the universe suffers. But I think one helpful thing to note, or at least maybe helpful is the wrong term, something that I noticed a while ago, and it's changed my view of markets a bit, so I'll share it for what it's worth. We use markets in different ways in antitrust, and we're not always precise when we do so. So there's you can use markets to look backward or forward, and that doesn't mean it has to be the same market in both cases. In a monopolization case, market definition, if it's useful at all, is typically employed to decide whether a firm is a monopolist. And Louis Caplow has exploded this by pointing out the complete circularity of it, and he's right. For purposes of looking backward and trying to get past the cellophane problem in order to say that the share is big enough that we can conclude that the firm's a monopolist because it's already raised its price, I don't know what to say why we do that, but we do it. So defining a market in order to look backward at whether firms have market power is one use. Another use is looking forward at what markets might be monopolized, where market power might be exerted. And there's no reason these have to be the same. So Microsoft is a pristine example of this. In Microsoft, the market was used looking backward at Microsoft's large share of the market to assess its dominance and ability to exclude competitors. But the market in which harm occurred was a different market. And the court wrapped itself around the axle trying to figure out some way to say, well, the harm occurs in the same market, but the share is this. It would have been far clearer just to say there's two markets, one in which we're assessing market power today and another in which we're assessing changes in market power. And I think that fits beautifully with your thinking that we could use different concepts of markets to great clarity relative to what we do now.
Yeah, that is a win. But go ahead.
I was just gonna say, I would add to that, to go back to Sean's point about categories making lawyers happy and everyone else worse off. I think anytime I'm on one of these and talking about the merger guidelines, I make the suggestion, and it never goes anywhere. I've never heard anybody pick it up, but I would like to see the agencies reissue the merger guidelines commentary, which hasn't been done since it was 2006 or something. But to your point, Bilal, rather than perhaps trying to categorize and label different markets within the guidelines themselves, I think an explanation of what the agencies are actually doing with respect to market definition in using illustrative cases could be really helpful without boxing the agencies in a way that there is a great deal of obviously anxiety about when writing guidelines. It's a common law doctrine. We ought to embrace that. And I think it would also, disabuse a lot of people of the notion that this isn't already going on. I mean, I think there is a misconception that the agencies don't bring potential competition cases, that agencies don't challenge lessening of competition in innovation markets, that agencies aren't thinking about technology. I don't think any of those things are true. And I think the cases, when you dig into them, including the ones that aren't litigated, bear that out. And I think some sort of showing of the math. We don't have a regime like in other countries where the agencies put out, closing statements on a regular basis. But a revised commentary, I think, could go a long way towards kind of right sizing what people understand about, what merger enforcement is doing and isn't doing, and maybe where the gaps are.
I strongly agree with that. There are these sort of ideas. It's like the idea that I hear all the time that, the federal government hasn't brought a monopolization case since Microsoft. It's like, that's wild. There's like 35 of them. It's crazy. So the idea that potential and nascent competition isn't alive and well, including, just as Kristen says, in cases that get abandoned or don't get the spotlight. I mean, I couldn't agree more. Point two on the commentaries, totally agree. Horizontal commentaries are on my desk. I just want to acknowledge the vertical commentaries from 2020, which are an extremely useful document. Whatever the ultimate fate of the vertical guidance, these are fabulously useful documents that I totally agree don't get the attention sometimes in some of these discussions that they deserve. Just to agree with, some of the things that both Sean and Kristen said about market definition, I sometimes wonder whether we would just do better instead of market definition if we asked as a gating or screening question, is harm from this practice or transaction plausible? And if so, how? And because while I totally agree with Kristen that the agencies, smart antitrust people who spend all day thinking about this stuff are not formalistic and encumbered by stepwise start at the beginning of the merger guidelines. What is the market go through? Totally agree. But who does sometimes is judges, right? And if there's one thing you need to do in an antitrust litigation, it is tell a really clear, really simple, consistent story. And if you are seen, perhaps by a generalist judge, to be playing games with market definition, right, being inconsistent in your allegations about competition, then all of a sudden, if it isn't hard enough for a plaintiff to win an antitrust case already, there's only one direction in which that's going to move the judge at the end of the day. So maybe, Sean mentioned that in relevant market is a sort of a harmful language that does some harm sometimes. I think right? We talk about what's the market, what's the relevant market. No. We're just looking for a story that's falsifiable by evidence about how some practice or transaction might lead to harm. And one might want to say, well, are we really asking whether it could lead to market power? That raises some complicated questions, maybe of terminology, if what we're talking about is contribution to oligopoly or, protecting coordinated effects from disruption. The story in its heart is always, is harm plausible here and how would we know? And then we go out at time 2 and test it. But that's maybe a hard thing to do in litigation with a judge who's maybe turning to antitrust for the first time in a while.
Any other comments? We have, I will put in a small plug for my draft paper on actual potential entry because it was an attempt, at least in the back half, to collect the FTC's potential competition cases and do something like a commentary. Of course, it can't substitute for the work of the agencies, but it was an attempt to show how the guidelines or the cases, sort of covered a variety of different theories of harm or of forms of harm. It's a draft, but I'll still put in a plug for it. Let me ask, I think we've covered a number of the topics we had planned to cover, and I may skip over them, but if I do and people feel, we should go back, please do. But let me ask one question before I jump ahead, and maybe to John and maybe others. Is there a way to include presumptions with respect to potential competition or nascent competition in the guidelines? The basic presumption or rough sorting factor appears to be concentration levels. Is there something you can do for potential competition or nascent competition that might be sort of a presumption, hopefully rebuttable presumption, but a presumption nonetheless?
I think conceptually, yes, but before we do that, and maybe I'm in the minority here, but I do think the labels matter for potential and nascent. I think, again, just going back quickly, the potential cases were about the entry of someone taking their beer from one market to another market, or entering into a bleach market or natural gas. Those are business decisions that I think the court has required some entry analysis as to whether it made sense or not. When we're talking about nascent competition, such as Steris, which is X-ray versus gamma technologies, X-ray had to develop in a certain way in order to be competitive with gamma. This is an order of magnitude more uncertain, but it's also orders of magnitude more disruptive in terms of the market effect. And so because of that, again, maybe I'm in the minority. I do think these terms do matter, both in terms of the law and the economics. That being said, in terms of presumptions about these concepts, I'm all for presumptions. We obviously, anyone who does antitrust relies on presumptions. They're important. We do market, whether formally or informally, I'm just going to use this loosely. Market shares matter, right? If it's a really low market share, what they do is no one really cares. If you have a 1-2% share, it's kind of a presumption that it doesn't matter. But if you're close to a monopoly or a significantly high share, yeah, we scrutinize you significantly more, and we worry about those things. And certainly practices such as price fixing, territorial allocations, it doesn't matter what your share is. We're going to condemn that as a per se violation, and again, rightly so. And what's the unifying theme of all this? It's not administrative cost, right? The goal of antitrust is not to lower administrative costs. That is part of the goal, but it's not the sole goal. We're worried about permitting anti-competitive conduct, improperly permitting that, or we're worried about improperly condemning pro-competitive conducts. And obviously that's the error cost framework. And while it sounds overstated, and here comes error cost again, it's incredibly important, because imagine if you're the defendant in a criminal case or in a business case of an antitrust, and you have a practice that you know you're innocent, and you have a practice that you know is quite beneficial, and someone just gives you a presumption saying, oh, okay, error costs are not so important. We just need to get these cases done quickly, easily, and lower the administrative costs. I think rightly you would object, and I think we should rightly object in principle to just lowering administrative costs per se. So that being said, what do we need to implement presumptions in this area or any area of the law? And I think it's just good, solid empirical evidence that these are consistently bad conduct within certain parameters, whether it's market power, whether it's just bad in general, like price fixing. What is it that we need? So to that end, if you examine the literature that's emerged on potential nascent competition, we'll just wrap those both in together for this purpose. Of those that I've read, I think there's about 3 or 4 good ones out there. The results, if we're being honest with ourselves, is decidedly mixed. It doesn't say they're all pro-competitive, doesn't say they're all anti-competitive. It just says it's really hard, even though we have the advantage of ex post analysis, we still can't tell. Maybe they were good, maybe they were bad, I'm not sure. Some look really kind of bad, some were definitely good. So what does that tell us? Well, like a lot of mergers, whether it's a direct competition merger or potential competition merger, it depends. There's some uncertainty, there's some probability element to that. Even looking at it ex post, it's hard. So how is it that we're going to justify a presumption against companies? And we're talking billion-dollar type deals. And so it's not just these, oh, they'll just rebuild it, etc. Take something like Amazon buying Kiva Systems, which was a robotics company that Amazon now is integrated into its warehouse. Whatever we think of Amazon, I think we can all share that they're fairly efficient in their delivery system, and Kiva Systems was a big part of that. Do we want to presumptively make that an illegal acquisition when the results are, I would imagine most would say, quite good for consumers and for welfare? So at the end of the day, I think I'm all for presumptions. We use them all the time, but I'm not for blind application of presumption under the guise that we need to lower the administrative cost of antitrust. Yes, we do, but I'm also worried about error costs.
I'd say, I don't think you're in the minority on the differentiating potential and nascent competition, but if you are, we are together in that minority, because I think there's a difference. Did anyone else want to comment, or I'll sort of move us forward a little?
I just thought I'd add, like, if this is a notoriously challenging problem, right? I basically share John's skepticism or caution about presumption. If we come up with a reliable way to tell now when entry is going to be a wild success or when a small player is going to turn into a fabulous competitive success, there are many, many more profitable ways to use that knowledge than improving antitrust heuristics. Like, we should just go do some VC for a year or whatever, right? So I think for a series of sort of reasons that are approaching obvious, that knowledge is almost never going to be operationalizable in a sort of easy, crisp presumption. Maybe that's what makes potential and nascent competition cases so difficult, that you're usually surfing outside of the warm, safe bubble of the structural presumption based on present observable facts. So I find it very hard to imagine how presumptions can be really useful in changing the shape of the landscape here.
Okay.
I love that your first thought is how to profit from this. It's like you'd phone in from your yacht to tell people how to do the presumption. The one tiny thing that I would add is I've always thought presumptions are an odd thing in antitrust. As an evidence teacher, it's always struck me they're such weak things that in antitrust we fear them the way we do. It's curious, but most of the presumptions in antitrust that we have today are tied to market shares, and market shares don't work great for lots of potential competition cases. Some they might, but not a lot. So to the extent that we're looking for presumptions here, it would probably be wise to look to other things to tie them to. I could imagine, for example, if there's a situation where error cost analysis suggests to us that failure to preserve potential competitors could have really large, really long-lasting consequences, maybe that would be a circumstance in which we could say that that view of the world leads us to presume harm. Beyond that, I struggle a bit to figure out what we could tie the presumption to.
Okay, it's fair.
Maybe this is obvious, but I'll say it out loud anyway, which is, the presumption has to be tied to the legal regime that we are talking about, which means that in addition to being logical and implementable and based on some kind of empirics, it has to be, as we say, merger specific, right? So a lot of the presumptions that are being tossed around or considered with respect to potential competition focus solely on the role of the acquirer or the power that they have, which does not actually tell you anything about whatever incremental effect might come from the transaction itself. And so I think that unless there is a change in the law on Section 7, I'm not sure that you can base a presumption solely on sort of the power or characteristics of one party. And as for the reasons that everyone's been talking about, it's very hard to develop observable and sort of empirical characteristics about the transaction that is necessarily sort of, more forward-looking, more maybe more dimly lit in the analysis than it might otherwise be.
Okay.
I think, anytime you're talking about potential nascent competitor, that the characterization of that entity is going to be individualized. I think if there's a presumption, in my view, anywhere here, it's really about the other company that may be a dominant firm in some relevant market. But I don't see that these potential nascent competition stories are susceptible to presumption. I think, 9 times out of 10, or maybe 9.9 times out of 10, the agency is going to court saying this is a special story, and so the judge is going to say, tell me about your special story. We're not going to get any shortcuts, to that. So
Interesting. Okay. If no other comments, I'm gonna skip 2 topics that I think we've at least touched on, which are, can we sort of improve our unilateral effects / exclusionary theories with respect to potential competition, and to the extent we have any, can we improve our coordinated effects sort of analysis? If we have time, we'll come back to it, but I want to touch on, I guess, what is old wine in new bottles, maybe. 2 theories that I wonder if we'll see in the guidelines. One is the concept of entrenchment, in the 60s or so, 60s and maybe into the 70s. And this underlays, I think, the Clorox case. We're concerned that these acquisitions would entrench a firm. I think of that as sort of monopoly maintenance now. Curious if they're different, except with respect to efficiencies. And then serial acquisitions. We've talked a little bit about that, but I think we want to touch on a little bit more. So let me, if no one objects, we're going to skip unilateral and coordinated, at least for now. Or you guys can sneak it in whenever. And ask Sean a little bit about the entrenchment theory. Sean is a worthy successor to Herb Hovenkamp, because he also seems to just go back and read all the old stuff that people haven't really thought about, and tries to refresh it. So entrenchment, what is it? Should it be in the guidelines? Should we fear it being in the guidelines?
Do you know how intimidating it is to teach the class that thought they were going to learn from Herb Hovenkamp? And it didn't help. Iowa has these huge oil paintings for anyone who's been there long enough, and he's like right outside the classroom. So every single case, it's like Hovenkamp, 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 and then they can leave the classroom and see who could have been teaching them. It was awful. Luckily now I've aged out of that. They don't know who he is, and I don't ever mention him anymore. So the question was entrenchment. One reason that Bilal's picking on me on this is that I have a paper on entrenchment where I tried to take back the word a little bit. So the 1960s and 70s cases on entrenchment are a bit of a mess in terms of kind of the logic of them. If you go back to the 68 guidelines, there's an entire section on entrenchment, section 20, which in the span of 2 sentences says like 5 different things. So it says when an acquisition of a leading firm in a relatively concentrated or rapidly concentrating market may serve to entrench or increase the market power of that firm or raise barriers to entry, it might be opposed. Those are 3 very separate things. Calling them all entrenchment is not really helping. Increasing market power is something that we think about all the time. There's nothing magical or new there. Raising barriers to entry is a separate question entirely. I don't want to address it because I haven't thought enough about it. Entrenching market power more in the kind of guise of monopoly maintenance is an interesting question, and it's one where I do think that the 2010 guidelines and in general a lot of the thinking over the last couple decades has kind of let that concept slide. So we think a lot about how mergers make things worse. That's language that when I was at the FTC was used constantly, especially in a coordinated effects case. How does this make coordinated effects worse? It isn't obvious to me that something needs to make it worse. One way to read a lot of those old Supreme Court cases is to say that if something is sufficiently bad already, then we should preserve opportunities for future improvement. So there's language to that effect in Philadelphia National Bank. There's language to that effect in a lot of the subsequent cases that dealt with conglomerate mergers. A lot of the thinking in those cases isn't brilliant, but the logic of preserving opportunities for future improvement is a coherent idea, and probably one that could be used more than it is now. So two examples of that seem pretty clear to me are if a market is currently pretty clearly oligopolistic, it's currently engaged in tacit collusion, as an economist would use the term, where, what's an example? Valspar. Titanium dioxide producers defend, well, yeah, we're all coordinating to raise price, but we're not agreeing. We're able to do this because we're already so concentrated. It would be very strange if antitrust then said, well, you're already doing such a good job. You can merge and you can acquire anyone you want. Can't get worse. So in that case, I think it makes sense to say, if you can point to a market like that, mergers in that area might be foreclosed even without showing that harm would occur in the future. The idea would be preserve any opportunity for improvement. And the same logic applies to potential competition mergers. In fact, it helps here. We wouldn't be focusing on what's the harm of the potential competition merger, a really difficult question. Instead, we'd be focusing on what's the harm of the status quo, and is there anything that we might plausibly do about it? Another example of that would be if there's a truly dominant monopolist that's just engaged in serial acquisition of nascent competitors, where any particular nascent competitor has a very small chance of doing anything. And indeed, especially if the monopolist is truly that dominant, that fact alone suggests that the probability of any particular nascent competitor doing anything is very low. But if the status quo is just going to be the monopolist there, again, we might preserve the opportunity for any one of those nascent competitors to shock us in a way that we might not predict, but by focusing on current harm as opposed to future harm, maybe we can get comfortable with it, as Kristen notes, within the framework of law. So there is language in the old cases that would allow us to do this, at least is my argument.
Let me ask if anyone has comments on that. I was going to kick it over to John, but others are welcome as well.
I just have a quick thought on that. And I don't, I haven't looked at this as Sean has. And so,
no one has looked at this like
yeah,
Sean.
I know who can really aspire to that. But in terms of the phrasing, yeah, when I see it, my thought is monopoly maintenance. And to the extent that, that's what people mean today, sure, it's a legitimate theory of harm. And I think well-versed, and because it's focused in on the harm. Its prior usage, though, this I do know, it was rejected at some point, at least, again, the prior use, it could be reformulated and repackaged. But the prior use was discarded, I think, in the early 80s by the DOJ, especially, and they got rid of it for the merger guidelines, their 1982 guidelines. So they didn't even include it in that, even though it was a working theory. And what the theory was then is that, okay, if you don't have your standard horizontal merger, you have this, it's not vertical. It's not even that potential. It's this non-horizontal, non-anything, conglomerate-ish merger. But you're big and you're buying something and you keep buying something. Should we be worried? And so one of the worries was that you're getting to be too efficient, which raises barriers to entry. Well, so do patents. And we tend to think those are good things. And also, you've just made life more difficult for entrants because you're in more product spaces, and to compete more effectively, you have to be in these spaces as well. I think rightly the DOJ has moved on from that theory because it's really kind of a protect the rival type-ish standard. And again, it can manifest itself into harm to consumers. It's not to suggest it can't. But it was unduly focused on the welfare of rivals as sort of the first and perhaps last step of the theory. And I think to the extent that we're moving in that direction, I think we should be cautious of the entrenchment theory. But as what Sean's trying to do is to sort of retake the phrasing, reformulate it in a sensible way. Sure, we can be legitimately concerned about these types of acquisitions that are serial, that might not be directly in one specific category. I think that's fine.
You can imagine, though, right, an adjacent category that, so, you know, the last thing I'd ever want to do is be heard standing up for efficiency offenses or P&G. I was, you know, I heard, I think it was Sean mentioned P&G earlier and my chest tightened. But there's a non-trivial set of at least possible cases that are basically complement foreclosure, right? They're vertical cases, but they involve complement foreclosure, where the traditional vertical theory of harm is that foreclosure results in multi-level entry being necessary for competition. And as a result, in a very common or garden consumer welfare competitive theory kind of way, we got a familiar vertical concern. And I've seen some of those cases labeled with entrenchment or moat-like language over time. And my instinct would be certainly to vigorously throw out the old efficiency offense cases or the P&G style stuff, while recognizing that just as we're serious about vertical concerns in a traditional sense, we should keep one eye open for complement foreclosure, because on the right set of facts, that's a serious story of competitive harm. And on the right set of facts, it might be right to bring that case.
Anyone else? It is an interesting topic.
Yeah, I'll just add, what Sean is talking about here is take us back to kind of John Bates Clark, right? And the origins of potential competition. And this notion that potential competition is a curative or corrective force for monopoly. And that's what we're talking about with this with his version of entrenchment, of an entrenchment theory is let's preserve the opportunity for that, for that curative or corrective force to exist in a market that's not as, has become entrenched. It's like oligopolistic. So.
Interesting. I wonder if, the so-called leading firm provision from the 82, 84 guidelines is helpful here. Maybe not fully helpful, but I wonder. I don't know if anyone has a comment on it, but I throw it out there. Okay, nobody. So look, we're approaching 3:30. Some people have to leave. Others will stay because, I think we could all talk about this for hours because, we like it. It's interesting. But I think for those who have to leave, I want to give them an opportunity to make some final remarks. And I think that is Daniel, John, and Kristen. So maybe in that order, I'd let you make, some closing thoughts, and then we'll, stay in the green room, so to speak, and keep talking.
I have no clever, inspiring final thoughts. I think what I would say is that the reason potential nascent competition cases are hard is deeply connected to the reason that many Section 7 cases are hard, which is we've got some indeterminacy in some places that really matter a lot, including, perhaps most of all, what's the affirmative standard for maybe, substantially, and what in the world are we doing about efficiencies? Here we are 107 years into the lifespan of Section 7 of the Clayton Act, and we still don't really have answers to any of those three questions. Like, that is a pretty embarrassing state of affairs. So to my mind, there's a sort of big picture or big ticket case for tweaking Section 7 to answer some of these questions really clearly and authoritatively, have it done through Congress so that we're not, going another 100 years waiting for these answers. And that, I think, will help potential and nascent competition cases just as it will more traditional ones.
So first, thank you for having me, Bilal. I really appreciate it. And my only final thought here is just to pick up a theme, an excellent point made by Kristen earlier when we were talking about presumptions and how it needs to be tethered to the facts of the market. And it just sparked a thought that, some of the proposals being made in sort of these tech bills abroad and domestically is to have presumptions against certain large platforms acquiring smaller firms under this theory. but it doesn't look at the realities of markets. Just to give you an example, Spotify is the leading streaming platform for music in the US. And I think Apple and others are getting closer, but they're still the market leader, yet they wouldn't fall under that presumption, whereas those who lag behind, like Amazon Music and Apple Music, would be under that presumption. And the reason why it's important is Spotify is going on a tear, buying a bunch of audiobook companies, buying a bunch of podcast companies, and they're very plain about it. And they say, we're jumpstarting our business and we're diversifying and we're keeping our market leadership and bringing these technologies to market faster. Good for Spotify. I'm all for that. But if that's good for the market leader, I think it's also good for market followers such as Amazon and Apple who are trying to catch up. And I think that disparate treatment shows how we've gotten so far ahead of ourselves that we've lost the tethering to the market. And so I just wanted to go back to that excellent point made earlier and just to give it a finer point. But thank you again.
Well, I'm going to say, Daniel, you're a worthy successor to Bob Potofsky, Harry First, and Eleanor Fox. And John, without, I'm going to say you're a worthy successor to Bill Kovacic, even though Josh and Tim and others, Doug, are still at Mason. So Kristen, I'll turn it over to you.
Thanks, Bilal, and I'll echo John's appreciation. This has been a really fun discussion. I guess to push back a little on Daniel's point about the ambiguity in the 107-year-old Clayton Act. I mean, I think that's what makes being an antitrust lawyer the best thing you can be in this world, because, right? I mean, our sort of bedrock statute, section 1, one sentence long, and the only thing we know for sure is it doesn't mean what it says, and that is full employment for everyone on this call and so many others out there. So I appreciate the academic and the practical challenges, and I think I said this earlier, I do think the flexibility here is both the greatest strength and the greatest challenge of the antitrust laws, and maybe it tips into more of a challenge in this space, but I continue to feel pretty confident in the abilities of the fine men and women at the agencies to get to the right result here. So I appreciate chatting with all of you.
All right, and you are a worthy successor to Von Kalinowski over there. Done. All right, so
you have these all queued up, Bilal? Did you
no.
decide earlier?
I think on my feet. I mean, this is the benefit of being the moderator and not really thinking substantive thoughts. I can free associate. So I mean, like I said, Daniel, John, and Kristen may need to leave. We will keep them involved as long as they're around. But let me turn to a couple other topics. We've talked a little bit about serial acquisitions. Let me ask. Well, let me start us off. Table set, right? The FTC's recent UMC policy statement referenced a few cases in which the commission, acting as a commission reviewing body, accepted, at least conceptually, that a series of acquisitions could have an anti-competitive effect, a cumulative effect or impact, even if no acquisition was illegal under Section 7. Now, the commission also challenged such acquisitions under Section 7 under the same cumulative effect theory later in the decade, but I have not dusted off all those books. And of course, the commission and DOJ officials in both the current administration and the most recent past administration have identified, a possible monopoly maintenance claims under Section 2 for such acquisitions. We've talked a little bit about that. Let me ask Tom first, and then Sean and Henry, if they'd like. First to Tom. Your work on the pre-merger notification program applies here, right? Can you tell us how the Hart-Scott-Rodino Act, both its the text, the exemptions, P&O's interpretations, both might affect or impact enforcement challenges to mergers involving nascent or potential competitors?
Sure. Thanks, Bilal. Yeah, I think probably a lot of the audience is aware, but for those that are not, the federal government requires firms that are interested in merging to notify them in advance, and then usually wait about 10 to 30 days. And this is in many ways essential to effective antitrust enforcement. Now, there are many exceptions to the Hart-Scott-Rodino Act, which establishes the pre-merger notification program. But I think the important point being here that there is a almost unambiguous result at this point that emerges from a host of recent papers, many of them written by me, that if you want effective merger policy, you really need to inform the agencies about a deal in its incipiency. And just to put this in perspective, like if a merger at the margin is exempted from the act, you can typically think of this like as close to a causal effect as you could get. Enforcement usually falls by about 90 percentage points. So it is virtually eliminated. Now, in theory, you could talk about consumer complaints, which will bind in some cases and not others. They would alert the agencies. In theory, you could also say, well, the agencies could take on a consummated transaction. But usually at that point, unfortunately, the assets have been commingled and the information has been shared. And I think, as many of us are fond of saying, at that point, the eggs are scrambled. And so, and I don't mean to sensationalize the problem in any way, but I think for many or most transactions, really the contours of the notification program then are in effect the contours of Section 7 entirely. And to the extent that's true, the reason I bring it up, I guess, is it has bite both for the nascent potential competition issue and also for serial acquisitions. And when it comes to the nascent or potential competition issue, part of the problem is that many of the target firms in those cases are going to be primarily intellectual property. And as a result, in those cases, they're going to face much higher thresholds than a normal merger would face under the notification program. So just to illustrate for everybody here, put it in perspective, let's say Sean has a startup, and that startup it's a tech startup. It's primarily has patents, trademarks, what have you, and I acquire it for less than $400 million today. That is typically not going to be reportable to the agencies. And if it doesn't receive a lot of press, media attention, no immediate consumer complaints, you might think that the practical rate of enforcement there is going to be basically zero. And naturally, then that's going to raise a question as to how much of the discussion over the guidelines or enforcement entirely or whatever becomes moot when we know that the agency isn't able to detect these deals in their incipiency. So I think that's a practical issue that the agencies are facing, and it's a hard one. You know, at a minimum, I think many people would agree that the agencies need more resources, and that the return on those resources, at least right now, at least at the margin, is very high. So I think a lot of people are hopeful of that, but that's a practical constraint at this point.
Okay. Yeah, I'll just put in a small plug for the NPRM and ANPRM that the commission released in the waning months of the past administration. They were intended to right size as best could be done in the scope of the rules, to right size enforcement, to try to eliminate things that were unlikely, or eliminate some things unlikely to raise substantive issues, but move away from interpretations or even exemptions that may have resulted in underreporting of substantive transactions. I don't want to overstate that. As people know, OPP looked at the acquisition activity of the five major platform companies, and although the report was sort of focused on a limited factor, which was sort of some I'll call it numerical analysis, you don't get the sense from that report that the agency missed a lot of substantive transactions. And contrary to what some of the commissioners or even acting chair said, the report, at least the effort intended to collect information that might give you some, initial sense of substantive issues. I mean, the 6B request was pretty broad, and it was, to see if, would this deal have triggered concerns, both based on, what I'll call pre-consummation documents and even after consummation documents. So, we want to be careful not overstating it, but it's clear that, transactions that are not reported to the government just don't get the look. And, the move from 15 million to 50 million back in roughly 2000 may not have been significant. But, this year we saw basically a $10 million jump in the, reporting threshold. And maybe that is material. We're now not at 50 million, we're at roughly 111 million. Maybe that's important, and maybe some thought ought to be given to revising the regime towards a more substantive focus on reporting. It's difficult, but we're just getting filings and can also swamp the agency, and it may not be the best way.
But I guess one thing I'd add there to your point is that I think when we do condition on acquisitions where the acquirer is somebody like Amazon or Facebook, I wonder if media attention, for example, takes care of a lot of this problem, that these things are raised to the agency, that people are following them pretty closely. And I wonder to what extent maybe the notice of rulemaking, the proposed changes that you had talked about, would really get at the heart of a different matter, which are business-to-business transactions, large roll-ups by private equity and so forth, which, at least in my own experience in the data, is really probably closer to the problem, and not Amazon and Apple per se, although they get certainly a lot of scrutiny. Maybe that reduces the scope of their problem.
And I'll just, before I go to Sean and Henry, I'll refer to the work of Liad Wagman and his colleagues that we, at least in part, tried to discuss last year around this time. Liad and his colleagues have looked at acquisitions across the tech space by a wider variety, wider category of companies, and worth, I think, people's attention to for both, what I'll call positive and negative effects or analysis. So let me just ask Sean and Henry, is there something about serial acquisitions that can be incorporated into the guidelines, that's not there? Is it, for example, a greater emphasis on Section 2 theories in the guidelines? There's a intro paragraph to each set of guidelines that talks about Section 7, Section 5, Section Sherman Act, but not a lot of development of separate strands of analysis under arguably different legal standards.
Henry has forgotten more about this topic than I will ever know, so I am going to defer to him.
Yeah, I mean, on serial acquisitions, the one case I would commend to people's reading and review is Foremost Dairies, FOREMOST Dairies, one of the orders that the FTC obtained against a bunch of several firms, large firms that were acquiring smaller dairies, back in the 40s and 50s. And that was articulated as a Section 5 theory. Now, I've always thought there is actually room for a Section 5 claim, right? It makes sense that, if you talk about Section 5 having this supplemental role to go after things that Section 7 or Section 2 can't reach. If you think about Section 5 having also an incipiency standard. So this idea that there's this creeping acquisition, a series of acquisitions, it's something that, I think it's worth exploring, and it would not be too edgy, if I'll use that term, for the commission to use Section 5 in this manner. So it's there. But if you go back to kind of the Foremost Dairies case and what was going on at the time, you'll see, though, that there was also an FTC report about the number of acquisitions that were happening in the dairy industry. And this goes to Tom's point about if they're not reported, has the FTC done an accurate job of capturing them all? And there's actually some writings from other people at the time that say, no, actually the FTC undercounts the number of acquisitions, and that if you have an accurate number of acquisitions, maybe the acquisitions made by firms like Foremost weren't that bad. So it's worth going back to and looking at. Caution, obviously, and this goes to John Yoon's point, we're talking about dairies, right? Now, today, we're talking about tech and IP and stuff. So a little harder to kind of say, well, what's the effect of all this, sum total of all this stuff coming under one roof versus, just, independent dairies going under a big firm. So that's what I would say.
And I haven't read fully that set of cases, or even Foremost, at least to commit it too close to the memory. But I think a couple of things were noticeable to me. Is it was potentially an effort, not to excuse it or from review or anything, but potentially an effort to expand into sort of a national network. These were horizontal acquisitions, these were vertical acquisitions,
Mhm.
some were small, some were large. You saw it in the grocery industry as well. So yeah, it is interesting. And I don't know if this is right. I mean, I remember, one of these, there was a discussion of, 400 acquisitions. Maybe it was Foremost. I mean, that makes, Amazon and Facebook
Exactly.
and Google look like pikers,
Yes.
And again, I'm not judging the merits of those, but interesting and different and something that's sort of dropped away.
Yeah.
If I don't know, Tom, do you have anything else you want to say, or I do want to jump to this asymmetric entry analysis that Sean and Henry have written on, that I think is important.
Sure,
but-
jump ahead. Good, Bilal.
Okay, so let's do that. There's a general sense that improvements to make it easier to bring a potential competition case may I don't want to say backfire, but may then make it easier and maybe appropriately so for defendants or respondents to say, well, if you think I'm going to enter, what about all these other guys, right? If this is sort of a capability test, someone who has a lot of money, well, there are a lot of companies with lots of money who could enter. But I think there's some tension there. I mean, even in the guidelines, they talk about the entry discussion in the guidelines talks about de novo post-merger sort of inspired entry. That's a little bit different than the analysis, of objective capability, that the copper mining company can move into oil and gas or vice versa, and I'm not, for a long time, I thought there should be symmetrical treatment. Now I'm not so sure, but you guys have done the hard work here. So let me turn it over to you for discussing it.
Henry, I think you would do a better job than me.
Well, so this was going to be my plug for something that could, we could see in revised guidelines below, right? So as we were talking earlier, what we think, what we expect agencies to do is to come up with a theory of competitive harm for a merger, and then to use tools like market definition to kind of tell that story, to develop that story. And my proposal would be, okay, entry actually goes hand in hand with market definition. You define a market, you understand who's in the market, and then you also proceed to characterize how firms enter and exit that market, right? And you do that so that, look, those tools are available offensively or defensively. If the entry if your characterization of the conditions of entry helps an offensive story of potential competition, the agency can use that. If it helps a defensive story of entry that corrects or compensates for the arguably harmful merger, the respondents can use that. But there should be a more robust section on entry in the guidelines right after market definition and market concentration. That's my proposal. So, Sean.
But I mean, it's really just saying the same thing, but maybe in a slightly different way. I think that I have become sort of the opposite of you, Bilal. I've become more convinced that these things are logically parallel and have to be, both logically and legally. So the example that sticks out to me, it is truly and profoundly weird that we live in a world in which actual potential competition always has an asterisk on it. That maybe this isn't a viable theory of harm. We're not really sure. And so most courts, if they want to be safe, will entertain the thought, but never find that it exists. At the same time, that we're completely willing to allow future corrective entry to constitute a defense. What's even weirder is where courts cite the existence of actual potential competition as the argument for why we should have a defense, because if you have one, you should have the other, while continuing to doubt the first one, but not the second. So these are things that should be symmetric and have not been for a long time. Throughout the 80s and 90s, the kind of, to my sense, way this worked was that everyone would say, well, potential competition theories are weird and doubtful, and we're not even sure that they work. They're odd theories, and they typically wouldn't win. By contrast, especially in the early 90s and late 80s, entry arguments were very powerful, and you didn't need a whole lot of proof to claim entry. Indeed, courts would ask, well, how can you prove entry won't happen, putting the burden on the plaintiff? That's a very strange asymmetry. Either entry is a plausible theory or it's not. It can't only be a plausible theory for one litigant. By contrast, today I kind of get the sense in commentary that a lot of people want to vastly invigorate potential competition in its offensive meaning. So making potential competition theories more viable, bringing them more often. To the extent that that evens out this asymmetry, I think that's an improvement. That's logical, and I think it makes sense. To the extent that the effort is to say, well, we think that potential competition is so important that even when we can't articulate how it would happen or where there's a low chance of entry, we should block those mergers from happening. If that's the argument, I don't see how you cannot also have that elevate the entry defense. If these are really so important, why are all of these potential entrants not important? So at a point of logic is really where I base my my argument here. I don't see a logical basis for separating them. And if there isn't a logical basis, then I presume that litigants will push this point. And if litigants push this point, I think courts will go along in saying it should be symmetric. In which case, I'm not really sure what the net effect of the merger guidelines trying to invigorate potential competition would be. And as Henry mentioned, I do worry that the net effect could be negative. There's an awful lot of firms that could be characterized as potential entrants. And if the effect of this is to make them all appear to be highly constraining, important competitors, the government could be shooting itself in the foot here.
So let me react a little bit to that. I mean, I think, Sean, I think we actually agree on a lot. What drove, I don't know what drove me to consider this idea of asymmetry is, and let me explain it, an easier case on the potential competition side and a still more rigorous test on the sort of de novo post-merger entry side is the idea that Section 7 is a prophylactic statute. So while I agree with John that, what we really should be doing is minimizing the sum of the error costs of over and under enforcement. Maybe, and this is tough for me to say, maybe there is some reason to, tilt in favor of a little bit of over enforcement on potential competition side or nascent competition side for the reasons we've sort of discussed before. You know, not that the status quo will get worse because of the activity or acquisition, but maybe the preferred state, you know, there's a probability, some probability that competition will get better absent, you know, a particular acquisition. So I think it should be some more rigorous thinking about, you know, what is sort of sufficient evidence of likely entry. But because of the prophylactic nature of Section 7, I'm reconsidering my, you know, hostility to this, you know, higher standard on one and low, arguably lower. And what I mean by that is, at least in the cases, you know, there's tended to be a focus on capability of entry, you know, the Supreme Court cases, some of the district court cases, although not the cases in the 80s, capability of entry, right? What apparently they call objective factors, lots of money, lots of talent, you know, other factors. And what I think they've referred to as subjective entry, you know, sort of would enter type things, you know, the incentives are there as well. And so the earlier cases seem to look at, you know, objective criteria, capability. Most of the FTC's, you know, potential competition, maybe even nascent competition cases, really are looking at, in almost all cases, right, is entry occurring? Not so much as their capability, but is somebody sort of taking actual steps to enter, right? I mean, you see it in the pharma cases, you know, what stage of, you know, phase 1, 2, 3 are they at, you know, clinical development. The two cases I put in opposition that were more capability oriented rather than maybe evidence of actual steps to enter, and you know, these could be very limited steps, but actual efforts, you know, are Nielsen Arbitron, where that looked to me like a capability question, right? These are the guys that seem to have the assets to do this newfangled reporting system. And then, and I'm probably going to get this mostly wrong, but you know, what was it? BP Amico, you know, development of oil, maybe oil and natural gas out in Alaska, right? That was, there were only a few companies that the commission believed were capable of doing that, you know, Exxon and BP, maybe it was Shell. It wasn't entirely clear to what degree they were. I mean, they were sort of taking steps to do it, but the commission, it was like, we can't see anyone else that even has the capability to do this. So, you know, I think the guidelines ought to be clear on the what I think the cases are referred to as objective and subjective, and that may help square this circle between, you know, Amazon's a potential entrant anywhere. I mean, apparently they are, you know, doing generic pharma now. You know, it seems good to me, but someone may think it's bad. But you know, Amazon, Facebook, other firms, a lot of resources, you know, courts have sometimes accepted them as a potential entrant in a market. Other times, or even the agency, other times said, well, no, just because they have a lot of money isn't sufficient. I think some discussion of that, you know, the sort of what used to be the sort of the would discussion on, you know, de novo entry would be useful to clarify where the agency is, you know, incentive and ability, not one or the other. So anyway, I say that, and I also say, we've got roughly 5 minutes before you guys have to leave. You can say whatever you want in those few minutes. I'll start with Tom. And Tom is a worthy successor to George Stigler.
Thanks, Bilal. I think that the one maybe aspect of this that when it comes to enforcement generally that I've taken away, and it comes back to your point as to whether we might over enforce in a few areas, assuming that we're not blocking obviously good deals. I think that the one thing that many people would admit, and this is true the farther right you move on the aisle, I think the more that this is true. If we don't do something, if we believe that part of these issues are competition related, and we believe that the remedy in a way is stronger Section 7 antitrust enforcement generally, I, at least personally, would much rather see these issues work themselves out as competition, maybe at the risk of over enforcing a little bit, rather than seeing what almost certainly we're going to see if that doesn't bear itself out, and that is we're going to have a lot more regulation. I think people can admit that if we don't do something about this and public sentiment continues in the way it is, we're going to have a different problem on our hands. And I think people who are the least likely to get excited about Section 7 enforcement are going to be the most upset about how this turns out. And for me, at least, that's led me to believe that while we may wind up with some over enforcement in areas, so we don't block obviously good deals, knocking out a few benign ones along the way might not be the most costly thing in the world.
Henry? And Henry, I'm not quite sure who you would be a worthy successor to at Bradley, but I will say a worthy successor to Tom Rush.
Thank you. I take that as a compliment, high compliment.
You should.
Yeah. No, so
A young Tom Rush.
So I will actually just, echo what you just said, Bilal, which is I do think that, yes, if we could expand the discussion of entry into guidelines, right? The agencies could talk sources of evidence, for instance, that go to capability and go to, intentions or motivations, incentives, whatnot. So I think, yeah, I think those could all be explored and everybody would have a clearer picture of what kind of evidence will, play out in a story about entry, whether it's offensive or defensive. So I think that's a good approach.
Okay, Sean, I'll give you almost the final word. I'm going to say one more thing, but you go ahead.
Okay, well, I'll be brief, and also I'll give a plug for Tom's work. I read a lot of articles, and there are very few that have just blown my mind the way, Tom, some of your recent stuff has. It in a really sad way. Like, I just stared at the ground, like thinking, what was the point of any of this? That a few tweaks to HSR made, like, it kind of makes you feel like almost everything is irrelevant, and it kind of makes you want to be an empiricist. So anyway, for anyone who hasn't read his work, it is amazing, and I strongly, strongly recommend it. I'll also just reiterate or just repeat the point, Tom, that you made. I think that the open question here is what is going to happen, not whether something should happen. And once you look at the frame that way, I think that puts emphasis on antitrust people who understand the subject to think really hard about what can we do that's going to result in good results. We know what we're doing in antitrust. We might not always agree on it, but we understand the problems. I think punting this to Congress, if we can't solve the problem, is a dangerous game. I will leave it at that.
So I'll make a similar remark. I was a little surprised that Daniel said that there was my words, not his, a positive role for Congress here. I think the room for a positive role by Congress is probably pretty narrow, and to my mind is, maybe some tweaks to the HSR Act itself. I think better the guidelines are improved. Look, I believe what I said at the beginning, that, Carl and Howard and Joe did a nice job with the guidelines, and also true of the vertical merger guidelines, that the team at FTC and DOJ did a nice job there. But improvements can be made, and those improvements are probably, in a sense, necessary to forestall Congress from doing what I would say are likely objectively bad things. And so I'll close with something, that agrees with what Sean, with I think what almost everyone has said. Tim Yaris said many years ago, and it was probably not unique to him, he said, you need effective antitrust enforcement because the alternative is regulation. And that is, I think, at least among, folks, many folks, that is a much worse outcome than, a few type 2 errors. on the, enforcement side. So, look, I want to thank everybody who's stuck around, both the panelists and attendees. This will be on YouTube, so you can watch it again. We're gonna try to turn this into some kind of written work product, because I think there's a lot of good stuff here. And maybe what I'd like to do is have this group back when we do see actual revised merger guidelines, and just do the same type of analysis, but maybe over a couple of sessions, because there's a lot. And I don't want to say we only scratched the surface, but we certainly missed some things in my outline. So with that, I'll say thank you. And I was going to ask John. I'm going to email him. I'm going to ask him for those 3 or 4 papers that he thinks are really good, and maybe post a link to them somewhere. On the evaluation of potential, empirical evaluation of potential and nascent competition transactions. So with that, unless there's anything more, I will say, thank you, and see you, in a couple of weeks, hopefully.
Thanks, Bilal.
Been
Thanks,
fantastic.
Bilal.
Thanks so
Thanks,
much.
Sean. Thanks, Tom.
Bye.
I